A discussion was held on 7 September 2023 in the monthly lecture program of Indian Federation of Women Lawyers Karnataka at the High Court of Karnataka, Bangalore, on the subject of legal rights of a wife over husband's property. Srimati S.R. Anuradha, designated senior advocate, High Court of Karnataka, was the guest speaker on the subject. All the members present in the program were actively participating in the discussion and were of the view that a resolution be passed and sent to all the appropriate authorities and departments and offices for action to amend the existing laws to the effect that a wife has equal rights over the husband's property, either movable or immovable, which have been acquired during the tenure of the marriage. And the resolution was accordingly sent to all the departments and offices and authorities for attention and needful action. Here are a few pictures of the discussion and the program.
ಬಹಳ ವರ್ಷದಿಂದ ಒಂದು 20 ವರ್ಷದಿಂದ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಅವರು ಯಾರೋ ನಂಗೆ ಗೊತ್ತು, ಬಟ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ನಾವು ಮೂಡ್ ಕೋರ್ಟ್ ಕಾಂಪಿಟೇಷನ್ ಜಡ್ಜ್ ಮಾಡಕ್ಕೆ ಹೋಗಿದ್ವಿ. ಸೊ ದೇ ಹ್ಯಾಡ್ ಕಾಲ್ ಮೀ ಬಿಕಾಸ್ ಐ ಹ್ಯಾಡ್ ಗಾನ್ ಟು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕಾಂಪಿಟೇಷನ್. ದೇ ವಾಂಟೆಡ್ ದಟ್. ಸೊ ಕಾಂಪಿಟೇಷನ್ ಎಲ್ಲ ಆದಮೇಲೆ ಬೇರೆ ಮಕ್ಕಳ ಸ್ಟೂಡೆಂಟ್ಸ್ ಎಲ್ಲ ಬಂದರು, ನಾವಿಬ್ಬರೇ ಜಡ್ಜಸ್ಸು. ಸೊ ಅವಾಗ ಏನಾದರೂ ಹೇಳಿ ಅಂತ, ಬಿಕಾಸ್ ದೇ ಆರ್ ಮೋರ್ ಕ್ಲೋಸರ್ ಟು ಮೀ, ದೇ ಆಸ್ಟ್ ಮೀ. ಅವಾಗ ಇನ್ನೂ ಜಡ್ಜ್ಗಳನ್ನ ಮತ್ತು ವಕೀಲರನ್ನ ಕರೆಯೋ ಅಷ್ಟೊಂದು ಸಂಪ್ರದಾಯ ಇರಲಿಲ್ಲ. ಓಲ್ಡ್ ಸ್ಟೂಡೆಂಟ್ಸ್ನ ಕರಿತಾ ಇತ್ತು ಜಾಸ್ತಿ. ಸೊ ನನ್ನನ್ನು ನೋಡಿ ಮಾತಾಡಿ ಅಂತಂದ್ರು. ನಮಗೆ ಗೊತ್ತಲ್ಲ ಅಂತಾರೆ, ನಮ್ಮ ಸಂಪ್ರದಾಯದಲ್ಲಿ ಸೀನಿಯರ್ ಫಸ್ಟು, ಆಮೇಲೆ ನಾವು ಜೂನಿಯರ್, ಆ ರೀತಿ ನಮ್ಮದು. ಸೊ ನಾನು ಅವಾಗ ಪಕ್ಕದಲ್ಲಿ ಇವ್ರು ನೋಡಿದೆ. ಸರ್ ಟ್ರೈ ಟು ಟೆಲ್ ದ ಸ್ಟೂಡೆಂಟ್, ಅವ್ರಿಗೆ ಮೊದಲು ಹೇಳ್ಬೇಕು ನೀವು, ನನ್ನಲ್ಲ ಅಂತ. ಸೊ ಅವ್ರನ್ನ ನೋಡಿ ಏನಾದ್ರು ಹೇಳ್ತೀರ ಅಂತ. ಅವಾಗ ಅವರು ಈ ಥಾಟ್ ದಟ್ ಐ ವಾಸ್ ಟ್ರೈಂಗ್ ಟು ಆಸ್ಕ್ ಹಿಮ್ ವಾಟ್ ಐ ಶುಡ್ ಡೂ. ಸೊ ವಿ ಟೋಲ್ಡ್ ಹಿಮ್ ಹೆಣ್ಮಕ್ಳ ಬಗ್ಗೆ ಮಾತಾಡಿ ಏನಾದ್ರು. ಹೆಣ್ಮಕ್ಳ ಬಗ್ಗೆ ಹೆಣ್ಮಕ್ಳೇ ಮಾತಾಡ್ಬೇಕಾ, ಬೇರೆ ಅವ್ರು ಯಾರು ಮಾತಾಡಲ್ವಾ, ಯಾಕೆ? ಇಟ್ ಇಸ್ ವೆರಿ ಅನ್ಫೇರ್ ಅಂತ ಅವತ್ತು ಅನ್ಕೊಂಡೆ. ಬಟ್ ಐ ಥಿಂಕ್ ಇನ್ 20 years of life ಐ ರಿಯಲೈಸ್ ನಮ್ಮ ಸಮಸ್ಯೆ ಬಗ್ಗೆ ನಾವೇ ಮಾತಾಡಬೇಕು. It was a hard lesson. I didn't understand the elder gentleman, he's an ex-advocate general. I didn't understand that day, and I felt a little let down that I've been asked to speak only about women. ಅವಾಗ ನಮಗೆ ಕಮರ್ಷಿಯಲ್ ಲಾ ಮಾಡಬೇಕು, ಟ್ಯಾಕ್ಸೇಷನ್ ಮಾಡಬೇಕು, ಆ ರೀತಿ ಸಬ್ಜೆಕ್ಟ್ಗಳು ಮಾಡಬೇಕು. ಹೆಣ್ಮಕ್ಳ ಸಮಸ್ಯೆಗಳು ಇದ್ದೇ ಇರುತ್ತೆ. ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ಅಂತ ನಮಗೆ. ಐ ನೆವರ್ ನ್ಯೂ ದಟ್ ವಿಮೆನ್ ಹ್ಯಾಡ್ ಪ್ರಾಬ್ಲಮ್ಸ್. ಐ ನ್ಯೂ ಇಟ್ ವಾಸ್ ಟಫ್. ಸೊ ವೆನ್ ಪ್ರಭಾಮೂರ್ತಿ ಆಸ್ಕ್ ಮೀ ಯಾವ ಬಗ್ಗೆ ಮಾತಾಡೋಣ, ಸೊ ಐ ಸೆಡ್ any commercial law, quickly I can come next week because I don't practice in this field. Then she said, ನಂಗೆ ಬಹಳ ದಿವಸದಿಂದ ಯಾವುದಾದ್ರೂ ಒಂದು ಕ್ರಾಂತಿಕಾರಕ ಸಬ್ಜೆಕ್ಟ್ ಇರಬೇಕು, something to do with women. I said yes. So by and large, in the past decade and a half, every activity concerning women, whether it is talks or mediation, I try to do as much pro bono as possible. ನಾವು ಸೇರಿದಾಗ ಐ ಥಿಂಕ್ 1 or 2 ಫ್ಯಾಮಿಲಿ ಕೊಟ್ಟಿದ್ದೀವಿ. ಈಗ ಎಷ್ಟು 7-8 ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಸ್ ಆಗಿದ್ದಾವೆ. ಸೊ ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದ ವಾಲ್ಯೂಮ್ ಆಫ್ ವರ್ಕ್, ಟುಡೇ ದೆರ್ ಈಸ್ ಅ ಹ್ಯೂಜ್ ಎಕನಾಮಿಕ್ ರಿಟರ್ನ್ಸ್ ಫಾರ್ ಎ ಪರ್ಸನ್ ಪ್ರಾಕ್ಟಿಸಿಂಗ್ ಇನ್ matrimonial laws. And I think we are as a society ready now to address this topic. So yes. So introduction I just gave you all. What's in fact, this is a very fluid topic. I wasn't sure how I'm going to structure to it. At the same time, it's a hard day. ನೀವೆಲ್ಲ ವಾಪಸ್ ಮನೆಗೆ ಬೇಗ ಹೋಗಬೇಕು ಅಂತ ಯೋಚನೆ ಮಾಡ್ತಿರ್ತೀರಿ. ಹೆಣ್ಮಕ್ಳು ಆಚರಣೆ ಮಾಡಬೇಕು, ಮನೆಗೆ ಹೋದ್ಮೇಲೂ ಎಲ್ಲ ಅಚ್ಚುಕಟ್ಟಾಗಿ ಮಾಡಿ, ಯು ಹ್ಯಾವ್ ಟು ಡೂ ಇಟ್. ಸೊ ಐ ವಾಸ್ ವಾಂಟಿಂಗ್ ವಾಟ್ ಇಸ್ ಇಟ್ ದಟ್ ಐ ವಿಲ್ ಡೂ. ಸೊ ವಾಟ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಡೂ ಇಸ್, ಐ ವಿಲ್ ಜಸ್ಟ್ ಗಿವ್ ಅ ಬ್ರೀಫ್ feedback as what are the rights of women to properties generally. But that is truly not connected to what I wish to tell in the end. But at least let us know from where we came. ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಸ್ವಲ್ಪವಾಗಿ we will talk as to what is the right of women. So ಸನಾತನ ಧರ್ಮದಲ್ಲಿ, this is a very popular and very controversial word today. So ಸನಾತನದಲ್ಲಿ ಹೆಣ್ಮಕ್ಳ ಪಾತ್ರ ಏನಿರುತ್ತೆ, what is that women would get in property. I think in Manu times we got nothing. agree with me. So the thought was, you be at the mercy either of the husband or the son. So ಮೊದಲು ತಂದೆ, ಆಮೇಲೆ ಗಂಡ, ಆಮೇಲೆ ಮಗ ಅಂತ. ಇದನ್ನೇ ನಾವು, so there was no thought process for a women to really think of anything. That was how it was. Even if you see in Mitakshara and Dayabhaga law also, that was the same. Though Mitakshara law nalli later on when we introduced 2005, Kajur they have spoken, which I have also spoken about it. Actually Mitakshara law said your particle will get succeed to your property rights. So what do we mean by particle andre ಒಬ್ಬ ಮನುಷ್ಯನ ಅಂಶಕ್ಕೆ ಅವನ ಆಸ್ತಿ ಹೋಗಬೇಕು ಅಂತ. ಅಂಶ ಅಂದ್ರೆ ಹೆಣ್ಮಗಳು ಅಂಶನೇ ಅಲ್ವಾ. But daughter also is a from particle of the father, so she should also get. Though that was the intention, but in practice it never happened. It always went to the sons, and the woman did not get anything. And maybe adrindane dowry pratha anta start agirbeku. We used to hear from advocates from rural areas when they would come, when we had a talk after the 2005 amendment came. ಅವ್ರು ಹೇಳಿದ್ರು ಮದುವೆ ಟೈಮ್ನಲ್ಲೇ ಒಂಥರ ಪಾರ್ಟಿಷನ್ ಥರ ಮಾಡಿ ಎಷ್ಟು ಕೊಡಬೇಕೋ ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ವಿ, ಅದನ್ನೇ ಅವರು ನೋಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರು. ಬಟ್ ಕೊಡ್ತಾ ಇದ್ರು ಯಾರಿಗೆ? ಗಂಡನಿಗೆ, ಅಳಿಯಂಗೆನೆ ಕೊಡ್ತಾ ಇದ್ರು. ಬಹಳ ರೇರ್ ಆಗಿ ತಾಯಿ ಏನಾದರೂ ಇಟ್ಕೊಂಡಿದ್ದಂಥ ಸ್ತ್ರೀಧನ ಮತ್ತೆ ಮಗಳಿಗೆ ಬರ್ತಾ ಇತ್ತು. ಅದು ಮತ್ತೆ ಮುಂದೆ ಅದು ಬಹಳ ಕಮ್ಮಿ ಅಂಶ, ನಾಟ್ ಸಮಥಿಂಗ್ ದಟ್ ದ ವುಮನ್ ಕುಡ್ ಸರ್ವೈವ್ ಆನ್. But in Aliya Santanam law, this is mainly because if you see anywhere in the world, ಇವಾಗ if you see Scandinavian countries, ಎಲ್ಲಿ ಸಮುದ್ರದ ತೀರ ಇರುತ್ತೋ ಅಲ್ಲೆಲ್ಲ ಅಳಿಯ ಸಂತಾನ ಅಂದರೆ ಹೆಣ್ಮಕ್ಳದೇ ಆಸ್ತಿಗೆ ವಾರಸುದಾರರು ಅನ್ನುವಂಥ ತತ್ವ. ಇದು ಅನಿವಾರ್ಯತೆಯಿಂದ, ನಾಟ್ ಬಿಕಾಸ್ ದೇ ಗೇವ್ ಇಟ್ ಟು ದ ವಿಮೆನ್. It was more because the man was a nomad, he would travel. So when they held property, the woman had to stay in one place. So that is how the Aliya Santanam law came, more of a practice and not to that anybody were conferred any kind of a right to the woman. It was more because of necessity is what I can say. And the first of the succession laws that we can say where women got some semblance of a rights was a limited estate right. Everybody knows this, we are all advocates. I'm just going to touch upon them and move. My intention is to give a talk for about 30 minutes, and then I want more discussion from thought process from you ladies, so we will put up a resolution as to what we want to send to the right persons. So this was the first, it was a limited estate, that too for a widow. Idar ಬಗ್ಗೆ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಲ್ಲ. So if there is any woman that is what I am also saying. So long as you are a wife, yes ma'am, that's what we want to say. Yes ma'am. Yes ma'am. Can we tell your name and then we are not. My name is Vasanta. Hi Vasanta, please tell me.
Actually, madam was just telling as long as the girl stays in that house, that depends on the amount depends on that. But some cases are such they cannot even survive for some days also in that house. The torture will be.
Then you get maintenance. There's a regular maintenance for that.
No, regular maintenance, even the one-time settlement also.
Alimony also is there. One-time settlement. This is a totally different law.
Yeah.
What we are here, this is a situation where women are coming out today for divorce because they are not able to sustain in the marriage for whatever reason it may be. If they come out, they are getting nothing.
Look at the marriage and then calculations we can ask, no?
That's what I'm saying. ಅದನ್ನ ಮಾಡೋದು ಬೇಡ ಅಂತ ನಾವು ಕೇಳೋದು 50% ಕೊಡಬೇಕು
See, if that is done, then only the man will know that when we divorce ಆದಾಗ he have that fear. ಇದೆಲ್ಲ ಕೊಡಬೇಕಾಗುತ್ತೆ, so that at least he will try to save the family than going to break up
But
the
that's also
family by
fair,
not
also
torturing the ladies. All that should be prescribed law.
Okay.
Yes.
Maintenance, that is the component that was coming there, but I don't think we should have that.
Any age, so we leave it to the legislators. Okay.
No.
Anyone else? We just wind up because everybody wants.
For that, you need to look at section 44 and 45, the transfer of property. Sorry if I'm appearing or talking like a lecture of a school.
No, but in
College.
that, have there any courts who have recognized the just mere contribution?
So you look into this. That act is saying who who has contributed. If there is no name mentioned, whether if you do not have sources from where, you have no proof from where the contribution has come, then if the property is in joint name, it goes to both of them.
Yeah.
If the property is in joint name, but you are able to prove that it came from two different sources, then two different persons will get proportionate to the contribution. So section 41 and 45, you also have to bear this in mind of the Concept of Property Act. So that is, we have to read section 27 and 41 and 45 together when we are making a claim in for the property.
So you are saying that it's already inbuilt in the
I'm not
petition?
saying
Yeah, exactly.
there is no recognition of matrimonial home and matrimonial property. Where is it available? Portuguese law in Goa.
Yeah, correct.
Portuguese law in Goa, they are following this.
Yeah.
They are following of what you call prenuptial agreements will be there. Whatever you acquired before marriage, what you are acquiring after marriage, what is your right, etc. If you take it in foreign jurisprudence, take in America or UK, where we are still following the British Commonwealth law, but still we have not made the change. We do not want to make the change because it is in the men's world, and they want to be the owner who wants to control or have the possessory right. That way even women are treated
No,
as
they
property.
treat the women itself property, right? So that's the question.
We are the shackle of the man, so your furniture, etc. We need a lot to make the distinction that women are not property, so we are not property. For the men. Okay, we needed all this to happen. So the men think in that manner. So I'm asking you to look into it. Yes, we need to have this kind of law. We have an example in Goa. I'm not saying it's the best example. It's already being practiced in India.
Yeah.
Goa is in India.
Yeah.
Of course, they have their Portuguese code which they are going to follow. Can that be made applicable? It's not. Take it to starter. Just for a starter, don't look into it. Now coming into the question is that did this attempt make? You spoke about, I think Prabha also mentioned about some law. I think Veerapampalli was the law minister did make an effort for bringing in irretrievable breakdown of marriage as
One of the grounds.
One of the grounds. At that point, he suggested there should be distribution of assets.
No, I thought he said the women will be given some kind of a salary.
No. So
For
what he said was there will be that when you're giving things.
salary for your home baker job, which I think was not accepted. I don't know. I stand corrected.
If you're looking into that Amendment Act said, if you look at it, my study or my reading of various studies shows who is approaching for the divorce. If you look at the rural women and the urban women, where I've done a study on all these things, and I'm writing the government of India report or writing the CEDAW report for women. So I was looking into all these things. So you can see most rural women have accepted that men can have more than one spouse. So they are not bothered about whether they're getting property or not. And what do most women want to have? Even if you look at the property that are there in India, I think 30% or 20% alone are the landed class, isn't the 20% population. 70 to 80% do not have any that kind of landed. What they have is a home.
Correct.
So when you say out of the marriage, where does she go? ಅಮ್ಮನ ಮನೆಗೆ ಹೋದ್ರೆ ಅಲ್ಲಿ ಬರಬೇಡ ನೀನು ಮನೆ ಮದುವೆ ಆದ್ಮೇಲೆ ಜಾಸ್ತಿ ಹೋಗುತ್ತೆ ನಾನು ಇಲ್ಲಿ ಬರಬಾರ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ಬರಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ಜಾಗ ಇಲ್ಲ, ಗಂಡನ ಮನೇಲಿ ಜಾಗ ಇಲ್ಲ, ಆಚೆ ಹೋಗುತ್ತೆ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ನನಗೆ ನನ್ನ ಅಣ್ಣ ತಮ್ಮಂದಿರ ನನಗೆ ಬಿಡ, ತಂದೆ ತಾಯಿ ಜಾಗ ಇರುತ್ತೆ. So one thing I think which we have to really educate and fight for is matrimonial home. In a very minute way which we have achieved.
So you don't want us to say assets.
No, I will tell you. I will tell you both. It's both. It's not that. Minute we are coming into Domestic Violence Act. We bought that in.
Yeah, and then brought it into right to residence.
Right to residence.
Yeah, right to residence.
Right to residence does not mean I have a right for home.
No. It's a right to stay.
Right.
Shelter.
Yes. So it's not just a shelter. It's not in the same house. If you see section 18, it says you not this house, any other house. 18, 19, 20 minutes. Any other identical house. So ನನಗೂ ಆ ಮನೆ ಗತಿ ಇಲ್ಲ. ಯಾವಾಗ ಬಿಟ್ಟೋಗ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಾಡಿಗೆ ಕೊಡೋದು ನಿಲ್ಲಿಸ್ಬಿಟ್ರೆ ಅದು ಇಲ್ಲ.
Correct. Or if he stops paying mortgage
As
also.
of right, we need to have a law which recognizes women having this right to property.
Yeah.
And that is a mandate that we need to have. And that's when you're talking, we call it assets.
So can we say present laws are not catering to this?
It is
Can
not,
we say?
yes,
Yeah.
it's not.
Yeah.
It's not. It's not adequate, and I think we are right. So if we are saying only why upon divorce, why should it not be that? See, with the communal property, you look at communal property, you look at American jurisprudence, that division comes only when there's separation. So what we pool, any acquisition post separation, again there's a different thing. So we are looking into this law. We need to study this jurisprudence to say what is it that we are going to request for or rather demand for. I would say yes, we need to have a equal rights to property and home.
Yeah,
Home
home
is something
acquired
mandatory
in-
for everybody.
in marriage.
In marriage, you have a right 50% upon divorce.
Should there be a minimum marriage years the wife should be, or how do you see that?
Yes, see there if you look at the studies, it says it depends. The longer you have spent, you are need to be given more.
More.
Suppose some people get married in 6 months, you're going for a divorce.
Yeah, then
that is one of the component even Rajneesh versus Neha is also looking
Yeah.
into saying that duration of marriage has to be taken
That's
into
what. So
consideration.
duration.
When you are granting a degree or maintenance amount. So some people you get married for 2 months, 6 months, 7 months, and then you ask for big fat alimony may not be justification. So how long that you have been there, all this, and another thing that we need to look into is that this judge, this Chennai High Court judge has come out with Prabha Sridhar, she has written a beautiful judgments on this unpaid, unmeasured domestic activity.
Okay.
In a sense, this has been recognized. If you are bringing this point, it is recognized in the when they made quantification for payment of compensation for a housewife who died.
For MVC.
MVC cases, compensation when it is tort compensation or MVC cases, they are quantified as 3,000
Yes.
3,000 rupees per month. Some sort of quantification, but at least they have looked into the fact that this you need to quantify the domestic contribution of a woman, which you are right.
I somehow don't want to bring
I'm
to
not
the
saying
MVC
I'm not
at
saying
all,
that.
because that is a very
Different
lose-lose
one.
situation for us.
I'm not saying
Yeah,
you go that way.
Huh.
I'm saying